between an offering and an actual funding is that even if it's not funded, the laws apply. And this leads to much more advanced work in preparation for the offering. And the statement, or the key document, is the registration statement, which must be filed with the SEC, describing the offering with all types of financial, non-financial, legal data in order for the public to make a proper evaluation of the risk and the opportunities in that particular company. So it's a major disclosure, and frankly, there's some of the most interesting reading are these S1 filings, the registration statements, because they do a good job, or they should, describing the company, its products, its services, its industry, and kind of a little bit about its future strategy, just as much as they feel comfortable sharing with prospective investors. So the process is very expensive because you're hiring a lot of high-priced talent. You're hiring SEC attorneys, not just any old attorney, but an SEC attorney. You're hiring CPA firms, but not just any old partner, an SEC partner, expert in the laws related to a public offering. Investment bankers, I've kept the most expensive for last. They will charge a lot of money if you're successful in having an IPO or any offering in the public markets. And these investment bankers, the CPA, the counsel, they're the team. They're the team that will go bring you to the public markets. So when we hear of things going wrong, which does occur, one is a security maybe have a rescission. Rescission means you take it back. Say, oh, we're no harm, no foul. We're returning all monies. We're withdrawing the offering. The other aspect is to avoid this embarrassing and very expensive and potentially fatal mistake. You could make sure that you complied with the laws or were exempt from securities laws. All right, so here's a word of caution. As mentioned on the very first slide, ignorance is no defense. So the regulators can look at your investment agreement and then alter it if it is deemed to be detrimental. So obviously you don't want someone else manipulating or changing the terms of your offering. And the SEC also can impose some very stiff penalties, including criminal prosecution, if you were to run afoul with their laws. So make sure you investigate the laws that pertain to you and hire a good attorney. Not just any attorney, securities attorney. And here's a pretty famous case. You probably know Bernie Madoff. And yeah, he made off with a lot of money. And there was an interesting movie about him, and you might look at it in Netflix or something. And it portrays him a little bit as a naive guy that got in way over his head. And once he was in it, he had no idea how to get out. And there was a fair amount of remorse. I don't know if that is in real life, but certainly the character as depicted in the movie had a lot of remorse. Again, that doesn't help matters because his fraud was in the billions. So it's unlawful for a person in an offer of sale of securities to employ any scheme to defraud, makes sense, to obtain money through untrue statements. Sometimes there's an untrue statement or an omission. And one thing is just overtly lie to somebody, but the other is to just leave out a very important fact. That's just as much as a lie, not telling a material fact, because the other party doesn't know the existence of that fact. So that is just like lying. Next is engaging in a transaction, practice, or course of business that has some fraud that is perpetrated on the purchaser. And again, this is the whole intent, is we don't want unsuspecting public to be investing in a company that is flawed. Next is to publish, give publicity to, or circulate any notice, advertising article, which, though not purportedly to offer the sale, describes the security for consideration from an issuer, underwriter, or dealer without fully disclosing the receipt of such consideration. So this is, consideration is money, right? And so we want to make sure that everything is described evenly to all investors, and there's no money exchange that is part of the securities. There's been many people prosecuted for violation of these laws because they're doing something a little bit on the edge, a little bit gray, but since we're dealing with very large sums of money, it gets a lot of attention. One of my classmates was attacked by the SEC on one of these items. If you would like more details, ask me in class about Friends of Frank, okay? Next is securities that are otherwise exempted from registration and not exempted from fraud. So we want to be careful about what is explicitly exempted, and if you think you qualify, guess what? Check with the securities attorney. All right, so let's look at the process on determining whether you have to register with the SEC. So is the entrepreneur offering a security? If it's not, then it's no registration. If it's yes, then you want to say, is it exempt? Exempt would be things like private offering exemption or accredited investor exemption, the Reg D, Reg A, or other exemptions. And then finally, we get to the endpoint, right? So the key is this box in the center, looking at the specific characteristics of your offering and who is the funder, the investors, that would enable you to not register with the SEC. So the two basic registration exemptions, the first is just for your information, it's probably not one that you'll use, is a government security. So if you are offering a municipal bond, that's exempt, but you're probably not going to be doing municipal financing. Or it's issued by a bank or thrift. Again, you may be in such positions over time, but probably not early and probably not as an entrepreneur. Certain securities by insurance companies. Again, that's a variation of financial institutions, and there are laws related to exempting some of their offerings. And then not-for-profit organizational securities. These are very specific, and the fundings are more complex sometimes for these not-for-profit companies. And then looking at the exemptions that occur during a bankruptcy proceeding. So the bankruptcy court and the judge may create securities that are for the benefit of the creditors, and those are exempt from the securities registration laws. And finally, intrastate offerings. So there are within a state of, say, California, if there's no interstate offering, there are some rules that pertain to that allow you to not register. So those are not the most common ones. So let's go through what are the common ones that you might encounter for a startup. All right. So these are the private offering where there are few investors. So if you have thousands of investors, no, that's too broad. It is now approaching the general public. So keeping it in a small group is key. Second is that the investors are accredited. Accredited here means that they either have a lot of money or they know a lot about business and investments, or both. And so these two in combination would provide you the ability to raise money without doing a public offering. So what does private mean? The number of offerees is limited, they must be sophisticated, and how you solicit cannot be widespread. You can't take out ads in newspapers and radio, television ads. It needs, all right, private placement, these are the Reg D exemptions. So the term safe harbor means that it is explicitly permissible. And safe harbor is used in all types of regulations. And in the area of securities regulation, there are certain safe harbor exemptions. So these are the Reg D exemptions. So the accredited investors, net worth greater than $1 million, excluding their residence, and their net income greater than $200,000 or $300,000 if joint. If it's a joint income, husband-wife scenario. And what are the alternatives? The alternatives are you could have a smaller offering. These are the Reg A offerings, and these are technically an exemption, and they're shorter, they're simpler, they're more like they look some ways like a public offering. The limit is $5 million, and there's no limit on the offering in terms of the number of offerees. And you cannot use it for SEC reporting companies. Otherwise, you'd go through registration. And you can use this for testing the water in advance of a larger offering. So these are Reg A offerings, either as the endpoint or as a test for some larger subsequent offering. And Reg SB, this is a small business. And here is some exemptions to make it easier for them to receive modest capital from public markets. Again, very specific scenarios. The Jobs Act of 2012 was to reduce some of the requirements to support emerging growth companies. Again, toward job creation and creation of more private enterprise. And these relate to crowdfunding. That was the $1 million maximum for crowdfunding, and force some registration limits, raised from 500 to 2,000. So This is because crowdfunding is by definition a crowd, and you need more. So this legitimized some of the crowdfunding mechanisms for financing of small businesses. So summarizing these chapters for session 2, chapters 7 and 8. Chapter 7, we looked at financial capital, and we looked at kind of the major differences between private and public markets and securities. And chapter 8 is just a brief touch into securities law and some of the major exemptions that are used by entrepreneurs when they seek to raise equity capital prior to going to an IPO, because it's way premature for a startup to go to some public offering. All right. So I'll see you guys in class. Thank you. Goodbye. Oh, one last item. You may notice that I'm sitting in front of a bunch of securities. I'm now in Mexico City, and I'm in a house that has a lot of history, and it was built by one of the early pioneers in mining in the country of Mexico, and it's kind of a cool place to be. And I'm doing some work in Mexico City, and again, if you want to ask me in class. It's kind of an interesting project. Thanks, and I'll see you in class soon. Bye-bye.